Hello everyone, welcome to Court with Krissy. This defendant, he's a little rambunctious, a little firework before the 4th of July, folks. You want to watch until the very, very end. My favorite C word. I hope you like it. Court with Krissy is now in session.
This is the right one. All right, last but not least, I'm going to call State of North Dakota versus Brian Lee Decker, 02-2026 CR 154. Present in court for the state, Attorney Tanya Duffy. Mr. Decker appears by reliable electronic means from the Barnes County Correctional Center. Mr. Decker, were you present in court when your rights were read to you earlier?
Yes, Your Honor.
Do you understand your rights?
Yes, sir.
One of the important rights you have is the right to be represented by counsel at every stage of the proceedings, including this one. The law presumes that people who are appearing in court for their initial appearance in custody, the law presumes those people are indigent, and ordinarily a public defender is appointed automatically to cover today's hearing. Before going on the record, the court received notice from the assigned public defender that you intended to offer a guilty plea today and waive your right to counsel. Is that correct?
Absolutely, yes.
Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to waive your right to counsel?
No, sir.
You understand that you don't have to waive counsel. I could order Ms. Chisholm to get back online and represent you today. You understand?
Well, sir, I don't want to drag all this out. It's going to come up in no, I'm just going to plead guilty. I'm just going to get it done with and not save the court's time and mine.
Okay, and so Mr. Decker, I just want to make sure I'm really clear and the record is really clear. You have the right to have counsel and you're waiving that right, sir.
Yes, sir.
All right, the court will find a knowing and voluntary waiver of the right to counsel. And the court finds that the defendant is aware of his constitutional rights as they were read at the beginning of the court session. Mr. Decker, have you received a copy of the charging document?
Yes, sir.
Do you have that document in front of you?
Yes, sir.
Is your name spelled correctly in the upper left-hand corner of that document?
Yes, Your Honor. Yes.
All right. And you have the right to have me read that document to you in its entirety, or I can summarize the document for you. Which would you prefer?
We can summarize.
The state alleges on or about July 1, 2026 in Barnes County, North Dakota, that you committed 3 criminal offenses, 2 Class B misdemeanors and an infraction. In count 1, the state alleges that you committed the offense of driving under the influence, first offense within 7, in that you were driving or were in actual physical control of a motor vehicle under the influence of a drug or substance or combination of drugs or substances to a degree that renders you incapable of safely driving. As charged, that is a Class B misdemeanor. And we're going to talk about the penalties for counts 1 and 2 together because they're both Class B misdemeanors. In count 2, the state alleges on or about that same date in Barnes County, North Dakota, you committed the offense of driving under suspension. And Ms. Duffy, are you alleging that the suspension was alcohol related or child support related?
No, Your Honor.
Okay.
No, it's not.
So just stick with me. So that driving under suspension, the state alleges that you operated a motor vehicle at a time when your license was suspended or revoked for any in any jurisdiction for some reason that wasn't alcohol related or it wasn't child support related.
No, sir.
That offense is also a Class B misdemeanor. For both counts 1 and 2, the maximum penalty for those Class B misdemeanors, maximum penalty is 30 days in jail, a fine of up to $1,500 or both, court fees totaling $250. On count 1, the driving under in the influence, there is an applicable minimum mandatory penalty. The minimum mandatory penalty is a requirement that you obtain an addiction evaluation from a licensed addiction counselor. There is a minimum mandatory penalty of a $500 fine And on counts 1 and 2, there is a minimum mandatory requirement that you submit fingerprints for inclusion in law enforcement's databases. Count 3, the state alleges on or about that same date, July 1, 2026, in Barnes County, North Dakota, that you committed the offense of unlawful possession of drug paraphernalia for use with marijuana or tetrahydrocannabinol. That is an infraction. An infraction is not punishable by jail. The maximum penalty for an infraction is a $1,000 fine, no applicable court fees, no applicable minimum mandatory penalties. For all 3 offenses, if your conduct caused any loss or financial harm to another person, the court can order restitution. For all 3 offenses, if you're not a United States citizen, a conviction can result in significant adverse immigration consequences. For all 3 offenses, if you're convicted of any one of them or all of them, there might be additional collateral consequences for which the court is not required to explain. An example of a collateral consequence, one among hundreds, if not thousands, of collateral consequences that might apply. In count 1, if you're convicted of driving under the influence, and in count 2, if you're convicted of driving under suspension, it likely will result in an additional consecutive license suspension or disqualification period. With respect to count 1, understand that if you get another DUI within 7 years, or if you get another 3 DUIs within 15 years, the offense gradation increases and the maximum penalties increase and the minimum mandatory penalties increase. For count 2, if you're able to restore your driving privileges within 60 days of the driving offense conduct date, so 60 days of July 1, you can move the court to dismiss the charge if you're able to restore your driving privileges within 60 days. If you're not able to restore your privileges within 60 days and your case is still pending, but you are able to restore your privileges while your case is still pending, sometimes the prosecutor will move to amend the charge or dismiss the charge, even though I can't force the prosecutor to do that or require the prosecutor to do that. Sometimes they still move to amend or dismiss the charge, even though they don't have to. You understand the nature of the charges and penalties as I've read them?
Yes, sir. Yes, Your Honor.
Do you understand that you can move to dismiss count 2 if you're able to restore your privileges within 60 days?
Yes, I could do that today, really. Well,
I'm just making sure that you understand that if you enter a guilty plea, you won't have that option. If you enter a not guilty plea, you would have that option if you're able to restore within 60 days. Understood?
I understand that. Then there's the option of bond and not being bonded out, and I'd rather not have to. It's all about money. I can't afford the whole pile of it. So I'd rather
right.
and work with it.
Just to be clear, you understand the charges and the penalties.
Yes, sir.
I am going to ask you for a plea of either guilty or not guilty to each of these 3 counts. If you enter a guilty plea, your case will be over today. If you enter a not guilty plea, we will set your bail and schedule further proceedings. Do you understand what happens if you plead not guilty?
Yes.
Do you understand what happens if you plead guilty?
Yes.
And Ms. Duffy, is there a plea agreement in this case?
No.
And so just to make sure, Mr. Decker, that you understand, the state is going to give me a sentencing recommendation if you plead guilty. And you can give me a sentencing recommendation if you plead guilty, but I'm free to impose whatever sentence I think is appropriate or just, and it might be harsher than what you would expect. It might not be. It might be the minimum mandatory penalty. But I want you to understand that I don't have to follow what the prosecutor is recommending. It's just that a recommendation.
Yes, Your Honor.
Understood?
Yes, sir.
So in count 1, driving under the influence, do you plead guilty or not guilty?
Guilty.
Count 2, driving under suspension, do you plead guilty or not guilty?
Guilty.
Count 3, unlawful possession of marijuana paraphernalia. To that count, how do you plead?
Not guilty. What? If you want to drag it on court, I'll plead guilty. Guilty. I ain't saying in jail. on the bond money.
I'm a bit confused. I want to make sure I understand.
I'm
Mr.
guilty
Decker,
of unlawful possession of drug paraphernalia, yes.
so Mr. Decker, are you pleading guilty or not guilty?
Guilty.
So the court will enter those guilty pleas. Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to plead guilty?
Nope. No, sir.
You understand that by pleading guilty that you're waiving all the rights that the court explained to you before?
Yes, Your Honor.
Do you understand that you're waiving any and all defenses that you could have had, any and all non-jurisdictional defects in the case if there are any, and you're limiting your ability to appeal the case if you enter non-conditional guilty pleas?
Yes.
And do you still want to plead guilty?
Guilty.
Are you doing so freely, knowingly, and voluntarily?
Yes.
Do you need any time to speak with a lawyer about your case?
No.
And my understanding is that there is no plea agreement in place. So if the court accepts your pleas, I will do so on an open plea basis. Do you understand that?
Yes.
All right. Ms. Duffy, a brief factual basis, please.
In this case, back on July 1st, 2026, Trooper Mishler was on patrol with the North Dakota Highway Patrol. He conducted a traffic stop of a vehicle on I-94 near mile marker 284 in Barnes County. Trooper Mishler had previously been provided information from a different trooper, Trooper Wenger, that he had witnessed the driver who had matched the description of an individual who had suspended driving privileges based on who the registered owner of that vehicle was. Trooper Mishler also observed the vehicle driving onto the yellow lane of the driver. As a result, he conducted a traffic stop. He made contact with the driver, who was the defendant. He identified the passenger as Timmy Linderman. Upon his approach, Trooper Mishler believed that the defendant was under the influence of controlled substances, specifically drugs. He conducted field sobriety testing on the defendant. All of those tests indicated impairment. The defendant, Trooper Mishler, believed he was under the influence of a controlled substance stimulant based on his testing and his experience. Subsequently, he was placed under arrest. In the meantime, the passenger was also placed under arrest for an outstanding Barnes County warrant. Search was conducted of the vehicle. Within that vehicle, they found some drug paraphernalia for use with marijuana. And at the time of this offense, the defendant's driving privileges were also suspended.
Mr. Decker, is that what happened?
Yes, sir. I was, in short, I was escorting a friend or an acquaintance, a guy I had run into. Says he's from the area, and he was wanted to see his mom, so he was bringing him out this way. I work at the data center in Fargo. I was bringing him out this way. I wasn't looking at enjoying time out. I paid $1,000 to get my license off suspension. I paid out my butt to get the thing registered and everything like that. So I'm like one payment away to get my insurance and license off. I had to get my permit. Person said his insurance in the permit. Then so I was like staggering. So here I am today with that driver suspension thing. I got so much money tied up into that. Then I was like $110 insurance, $29 insurance and a permit, and bam, I'd be legal. But apparently I wasn't. And as far as using drugs, I've been sober for over a year. I take Vyvanse. I have a doctor's prescription. I'm working on my medical card. The same doctor. As far as the marijuana stuff, that's not mine. The possession of it, but it's on the docket. I'm pretty familiar with the court systems, and I don't have enough money to pay bond and all that stuff. I'm not really wanting to do all that. I'm working with the Ridge, a whole bunch of people in Fargo. As far as like the status I'm on today, I don't know much more I can tell you. As far as actual using any drugs or DUI, no, but I am on a prescription Vyvanse, which may have, so, and then I took a urine test. He breathalyzed me. Of course, I blew zeros. I don't know what more you want from me. I'm not really enjoying the court system anymore in my life. I've been sober a year, and I'm trying to get away from it all appropriately. So my fastest way I'm thinking out of jail is to plead guilty and leave it to your honor's hands, because I don't believe in my knowledge. I am on medicine. I have it in my backpack. I have a prescription. I have my weed card. I have everything but my legal license to be pulled over, and that's a $29 insurance payment, which I was going to do yesterday, but I couldn't get a insurance company because I had a permit and then take the test. I got $1,000 to get free of my suspension. I got all this money, I just can't keep on doing. And now I work at the data center, I'm probably lose that job if you keep me in jail. So that's $110,000 a year. So I'm not messing up. I'm not doing nothing wrong. I really am not.
Mr. Decker,
Was
I
there
want to make sure, stop talking now. What I heard from you is I was driving fine. My license is almost restored.
Yes,
The
sir.
weed stuff isn't mine and I have a valid prescription for it. The drug that I was under the influence of is a prescription drug
Yes, sir.
and that I was taking it as prescribed. So what you're talking about sounds like a whole lot of defenses.
Yes.
And you also mentioned that you're pleading guilty just to get out of jail, not because you are in fact guilty. Those are generally things that are problems for me because I don't accept guilty pleas from people who aren't guilty of the offenses.
Thank you, Your Honor, for listening. I don't feel
So
guilty. I
You
don't.
need to stop talking. Like, just close it.
I'm sorry.
So your speech is also very, very pressured and fast. And it causes me some concerns that you might still be under the influence of some form of stimulant. I know you were arrested yesterday. I have some concerns about this plea because you're not telling me that you're in fact guilty. You're telling me a whole bunch of things that constitute defenses. Are you telling me otherwise now, or are you telling me not to accept your guilty pleas?
I'm not guilty. I'm not guilty, but I'm pleading guilty. You're the judge. You decide. Either way, I'm gonna go to jail. I can't afford to fight your whole shit. And either way, I'm in jail.
You need to make sure you're not swearing in my courtroom.
Sorry.
You might not be
I can't
physically
afford to- I
present in
can't
my
afford to-
courtroom, but you're talking
I
right
can't-
now and you're
Connor,
swearing
I can't-
again. Stop.
I can't afford to fight your court system. I'm not gonna try. I'd rather be guilty and get it over with. As far as your opinion of me being on drugs, cancel that because I am not.
Yeah,
Okay.
so,
You're reading a screen and you're profiling up.
all right, you need to stop talking.
How you're doing. I'm not guilty, but I plead guilty. I'll end it there. Rose, you give me 30 days anyway. So,
I asked the court to set bond, withdraw his guilty pleas and set it for further hearings.
I'm guilty. I'm not having that.
Sir, stop talking.
I'm guilty and I want to be charged guilty. I'm not dragging
Stop
the court
talking.
system. I am
We're
guilty.
done. I'm going to withdraw the defendant's guilty plea. I'm going to set bond. Sir, if you talk again, I'm going to mute the jail. You're talking out of turn. If that doesn't work, sir, I don't know what else to tell you. You need to hold off right now, okay? So I'm telling you to stop talking.
Yes,
You need to follow the court's order. Do you understand?
yes. I'm losing $110,000 an hour job, a year job right now.
So
So what I'm gonna do if you keep me in jail. $110,000.
don't talk out of turn again. I'm asking you, do you understand my warning?
Yes, sir.
Now follow the court's order, which was to stop talking.
Thank you.
I am withdrawing the defendant's guilty plea. I have not accepted them. I have not found that they were freely, knowingly, and voluntarily entered, nor have I found an adequate factual basis. So under Rule 11D, the defendant has the absolute right to withdraw a guilty plea. I'm not accepting the defendant's guilty plea. Was a request by the state, and frankly, that was what the court was going to order anyway. So I'm granting that request. Pleas are withdrawn. Not guilty pleas are entered on behalf of the defendant. I'm going to hear first from the state on bail, and then, Mr. Decker, I will give you an opportunity to be heard on bail. But you need to remain silent until I hear from the state. Ms. Duffy.
In this case, Your Honor, the defendant, his criminal history begins in 1991 with several NSF and no account cases, disorderly conduct 92, possession of marijuana. There's quite a few driving under suspensions along the way. Burglary 97, forgery 1997, criminal trespass 1998, felony bail jumping 1998, violation of protection order 2001, drug paraphernalia 2001, felony protection order violations times 10 in 2001, attempted violation of protection order 2001, separate cases, 2 separate cases of forgery in 2002, felony theft in 2007, forgery 2007, some more NSFs in 2010, simple assault 2010, marijuana 2010, drugs in a motor vehicle in 2010, ingestion 2010, forgery ×4 2010, DUI in 2012, harassment in 2018. He's got more driving under suspensions in 2018 and 19. Fleeing in 2018, another in NSF in 2019, theft ×2 and forgery again ×2 in 2020. Another forgery, separate cases in 2020, petty theft 2020, violation of disorderly conduct restraining order and orders prohibiting contact in 2020. 2 separate cases of the disorderly conduct restraining order violations, disobedience of a judicial order in 2020. Another incidents of the violation, disorderly conduct restraining order and disobedience in 2021. Unauthorized use ×2 and theft of a credit card in 2021. Possession of meth in 2021. Felony meth and drug paraphernalia in 2021. Possession of marijuana 2022. Disobedience 2022. Possession of meth and criminal trespass in 2023. Resisting law enforcement 2023. Felony drug paraphernalia in 2025. Some infraction marijuana ×2 in 2025. Felony meth and felony drug paraphernalia from 2025. He should be on parole right now for that. He received a 2-year sentence that was imposed in July of last year, so he should be on parole, presumably because it's not been 2 years since last July. So he should be on parole status for that last case. I didn't check about probationary or parole statuses for the cases before that. The defendant has a Drake, North Dakota address, so I don't know that he has any ties to Barnes County. I don't think any of his cases really came out of Barnes County. There's some in neighboring counties, but not Barnes that I recall seeing. I'd ask the court to set bond at $2,500 cash or in the alternative of $5,000 surety. A requirement that he maintain contact with his parole officer, no leaving the state, no driving without a valid license and insurance. Remain law abiding, no drugs or alcohol without a prescription, and any other conditions that the court deems to be appropriate.
What's the file he should be on parole for?
He should be on. It should be 09-2025 CR 2379.
2379.
Correct.
All right. Mr. Decker, you have the absolute right to remain silent. If you choose to remain silent, your silence will not be used against you. You have the right to give me a statement on bail if you wish. But again, anything you say can and will be used against you. These are recorded proceedings. The prosecutor can get a copy of the transcript and use any statements of fact that you make against you in these proceedings or in other proceedings. Do you understand the court's warning?
Yes, Your Honor.
Is there anything that you want to tell me about bail before I set it?
Yes, if I may. There are several factors including bail. One, I have a vehicle that's sitting on the road, and if I can't make the bail, that's going to cost me money. 2, I don't have enough funds for bail. I'm from the Fargo area. I'm doing very well. I'm on parole. I work with the Ridge, recovery reentry center, all kinds of good stuff going on in my life. As far as ever not appearing for court, that doesn't seem to be ever an issue. And if it was ever on print, it's probably because I was in a jail, missed another court in another jail. And so that's never been an issue where I ran from a court hearing or afraid to go to a court hearing. That's not an issue. I'm doing so well in life right now, and the finances put into it are enormous. And to have this collapse under me is tough to do. And that if I can't afford to bail to get my vehicle to go back to work, I mean that's I can't. I mean I got everything I got going on financially out there. I mean, but I ain't in trouble as far as like a massive society or I'm doing really well. I'm really managed really well, Fargo. Really, those guys are awesome. And as far as like, I don't know what more I can tell you. Am I gonna not miss court? Obviously, I'm not gonna miss court. Can I afford a bail? No, I cannot. If I have a vehicle on the road that's cost money, I got a job that's gonna cost me money, all this, but I don't have the money to do $500. Up here, I'm good. The Ridge will get me there. For real. Those guys are doing. So I know it's time. As far as my advice worth money to secure coming to court versus my word, I apologize. The money's worth more than my word, but my word is obviously being bring to court. I haven't missed a word of court here ever. I don't run. I don't need to. And I'm more worried about losing the pile of stuff I have going on that's positive in my life. And I'm gonna end the shot anyway. That's why I was hoping just to get done and go and not lose everything. Versus dragging around on $500 is going to cost me a lifetime of my money. It's going to cost me a life. You know, not literally, but what I built up, what I got going on today. With all the charges back behind me and where I'm at today and in the beautiful how I am, you know, that $500 is going to collapse my whole world. If I just can't go and come back on a later date to court. It's going to cost me everything, a lot.
All right.
Come see his mom. He didn't even go stop and see her. I mean, come on. That's painful.
Mr. Decker, I'm going to set bail here in just a moment. I'm going to tell you right now, your next court date is October 6, 2026 at 1 p.m. Central Time in the Barnes County Courthouse in Valley City, North Dakota. That date, one more time, October 6, 2026 at 1 p.m. Central Time. To understand when you next need to be in court.
Sure.
I am going to remind you, and I've already made a finding that you waive the right to counsel, but I'm going to remind you, sir, that if you want counsel, it sounds like you probably would financially qualify for a public defender to help you. You can always decide to hire a lawyer, and you can always decide to apply for a public defender at a later time, but it's in your best interest so your lawyer can help you and make decisions with you and give you advice if you apply for a public defender sooner rather than later. Do you understand? You can always change your mind about the right to a public defender as long as your case is still pending.
Yes, thank you.
All right. The court's considered the constitutional provisions concerning bail, including Article 1, Section 11 of the North Dakota State Constitution. The court's considered Rule 46, in particular Rule 46A, that has a presumption of release on one's recognizance or unsecured appearance bond unless the court has sufficient evidence before it to rebut the presumption of release on unsecured appearance bond to ensure the defendant appears. The state indicated Mr. Decker has some previous bail jumping and non-appearances. That posed the court some concern. Mr. Decker asserts that he has always made it to court. Court finds that the state's recitation of a bail jumping conviction is sufficient to rebut the presumption. The court's weighed the factors set forth in Rule 46A3 on release. The court finds the following bail to be appropriate and reasonable under the facts and circumstances of the case, including the nature and circumstances of the offense, the defendant's criminal history, the ties to the community, and the other factors the court is required to consider. The court has considered the declaration of probable cause. This was a search warrant case. I granted the search warrant based on the statements made by the trooper at the time. And so I know there's going to be a chemical test returned at some point. Courts again weighed those factors. The fact that the defendant has a rather lengthy criminal history, that he's currently on parole in file 09-2025 CR 2379, that he has a parole officer in that file, the fact that this is charged as a B misdemeanor level case, it's a driving offense or what could arguably be construed as a victimless crime. I don't think that it is victimless. Society is the victim in this type of offense. The courts weighed the dangerousness to the community, risk of non-appearance, flight. And again, all those factors that are set forth in Rule 46A3. Court finds the following bail is sufficient but not greater than necessary to secure the defendant's appearance. And the court further finds that the non-monetary conditions that are imposed are tied to the Rule 46 release factors and appropriate to ensure the defendant appears when required. Bail will be set for the time being at $1,000 cash or an alternative $3,000 corporate surety. In addition, in addition to those monetary bail conditions, which are imposed in the alternative at the defendant's option, the following additional conditions also will apply. The defendant shall remain law-abiding, not leave North Dakota without the advanced express permission of the court, notify the court of any change of address, employment, phone number, or email within 24 hours of any such change, not possess or use alcohol or controlled substances unless prescribed.
I'll take my son on. I'm done.
Sit down.
You ruined my life. I don't need to live.
Mr. Decker,
It's
walk away from the court, sit down, or I will hold you in contempt.
Well, there's not $1,000. You ruined my fucking life.
Stop talking while
I
I'm
don't give a
finishing.
fuck what you're saying, sir. You can fuck off.
Sir,
Fuck
I'm
off.
holding you in contempt for conduct that occurred in the
Fuck
court's
off.
presence.
$1,000. You ruined my life. You can fuck off.
Sir,
Fuck off.
I have repeatedly warned you. You
I
are
said,
not.
fuck off. $1,000. You ruined my life.
Summary
You can
contempt.
fuck off, Judge.
I'm
$1,000.
imposing a $500 fine as a summary contempt. Sit down. Mr. Decker is flipping me off. The jail has muted the microphone. He has walked away from the court several times. Conditions are as follows: remain law-abiding, not leave North Dakota without the advance express permission of the court, notify the court of any change of address, employment, phone number, or email within 24 hours of any such change, not possess or use alcohol or controlled substances unless prescribed, sign a promise to appear in waiver of extradition before release, comply with all currently imposed parole and or probation conditions in file 09-2025 CR 2379, which are incorporated by reference into the court's bond order. Meet with Mr. Decker's parole and probation officer within 72 hours of release. Have minimum weekly contact with the parole and probation office. Personally appear for all scheduled court hearings. Your next court date, sir, October 6, 2026 at 1 p.m. Central Time, Barnes County Courthouse in Valley City, North Dakota. Submit fingerprints before release. Not drive or operate a motor vehicle without a valid license or permit to do so, and valid liability insurance as required by North Dakota law. Again, the court has imposed a $500 fine for the defendant's willful and intentional contempt of court, for swearing and cursing at the court after being given warnings to do so, getting up during the proceedings, interrupting the court's proceedings in the court's presence, and obstructing the court's process and abusing the dignity of the court. As such, the court imposed a $500 contempt finding. And I'm doing so under the court's authority under the statute, which I will read in just a moment. Under North Dakota Century Code, Chapter 2710, 01.2, the court may impose a remedial or punitive sanction for contempt of court under this chapter. Contempt as defined by Century Code Section 2710-01.1, Sub 1, Sub A includes intentional misconduct in the presence of the court which interferes with the court proceeding or with the administration of justice, or which impairs the respect due the court. A punitive sanction includes a sanction of imprisonment if the sentence is for a definite period of time. A sanction requiring a payment of a sum of money is punitive if the sanction is not conditioned upon performance or non-performance of an act, and the sanction's purpose is to uphold the authority of the court. Here, the court finds Mr. Decker's behavior constitutes intentional misconduct in the presence of the court. The court finds that Mr. Decker's conduct interfered with the court proceeding or with the administration of justice and impairs due respect to the court. The court imposed a $500 sanction, which the court intends to be punitive in nature. And again, it is not conditioned upon the performance or non-performance of an act. The court finds beyond a reasonable doubt that that offense or that conduct occurred. And again, the sanction's purpose is to uphold the authority and dignity of the court. An order of contempt will issue in writing. Ms. Duffy, do you have any questions about the court's order?
No, Your Honor.
Do you have any questions about any other portion of today's proceedings?
No, Your Honor.
I'll have the jail unmute Mr. Decker.
I have a right to remain silent. I choose to do so.
Stop talking until I ask you a question.
I understand the clock saying I have a right to remain silent. I have nothing to
Mr.
say.
Decker, do you understand the court's bail order?
I say nothing to you.
Mr.
You
Decker,
understand?
I asked you a question. Do you understand the court's bail order?
Yeah, I said fuck off. I say nothing to you.
Mr. Decker, if you continue to swear in court, I will hold you in contempt again.
Oh, no.
I'd prefer that you don't do that.
Okay, go ask some questions. I said fuck off. I ain't saying no.
Sir, you are
Yeah.
a breath.
$1,000 because you ruined my life for $1,000. Fuck off, Judge. I got no respect for you.
Again, sir,
Fuck off. I said.
I'm holding you in contempt again.
Again, you're a
Imposing
powerful diaper.
$50. It is punitive.
Diaper powerful. Fuck off.
All right, we're done.
$1,000, you punk bitch. Fuck off.
Issue a written
You talk like that, you piece of shit.
done.